Well, many thanks here on News Desk. Let's do a lot more stories now. And the Ghana Independent Broadcasters Association has filed a written court seeking an interpretation on a new content law by the National Media Commission. Now, there's been a raging debate over what some have described as a policy by the Media Commission to curtail media freedom. That's a claim that the NMC has blatantly rejected, though. But let's try and get more on this suit from the Ghana Independent Broadcasters Association, that's GIBA, and Akwesi Ajiman is president of the association. He joins us on phone now with a lot more. So, Mr. Ajiman, good morning, many thanks for your time. Now, can you tell us once more what really you are seeking in court?
Thank you, and greetings to your listeners. I believe a couple of weeks ago we indicated our intention to go to court to seek interpretation on this new LI. And that is exactly what we have done, because we feel there are certain aspects of the regulations that go contrary to the constitution of the country, and the Supreme Court is the best place to get interpretation for it, and so that's what we are doing.
So which aspects again are worrisome for you and your association?
I mean, the fact that you have to seek content authorization itself, I mean, doesn't sit well for us. Given the background that the Constitution says there shall be no impediment in the establishment of private media in the country. And so we feel that there seems to be a contradiction there. And then there's also this issue of custodial sentences. And we feel that if, as it were, people are going to be imprisoned, for the lack of a better word, for their content, then we're probably leading into censorship and all that. So we feel that the Supreme Court must give interpretation on that and seek to expunge those parts of the regulations that are contrary to what the Constitution says. But let me just put it on record that we are not in the industry. We are not against sanitizing the system. All we are saying is that we must do things according to what the Constitution of Ghana says.
So, Mr. Ajiman, let me ask. I mean, you mentioned 2 points here. You mentioned the content authorization as one of the concerns you have. Also, the custodial sentence, and a bit of that particular LI that speaks of custodial sentencing. Now, I would like to start off first with the content authorization. Now, the NMC makes us aware that this is nothing new. It's already been happening. They're just getting legal backing for this particular issue of content authorization. So, why really are we going to court
again? It is already happening. I don't know that for a fact. What we have is the technical standards which are set by the NCA, and so you go for frequency allocation. So NCA, and that's why they carefully worded what they give us. They give us frequency, authorization, and allocation. And so that is different from content authorization. Content authorization then sits with censorship, because if I have to bring you my programming guide to let you know the content that I'm going to put on my platform, for you to authorize it, I mean, I don't know how else you will define censorship. And so that is problematic. And so if the NMC says it's already happening, we have not gone to NMC to see content authorization before, but now they're asking us, so it can't be something that is already happening. It's something that they are introducing. And we are saying, if properly so, then they should be teaming up with the NCA so that you have one body that looks at these things. But now going to NCA now, after that, which one comes first? Do you seek the content authorization before you get your frequency allocation or authorization, or do you get a frequency authorization? And if you get a frequency authorization, will the NMC then say, I cannot let you broadcast a particular content? Will that not amount to censorship? So those are matters that are a little bit gray. We feel that we need interpretation in the Supreme Court, and so that's what we have done.
Also on the issue of custodial sentencing, well, the information we have is that it's just to encourage responsible journalism. And also, it doesn't even have to do with the journalists. It has to do with the media owners. So really...
so if the Constitution says publishers and editorial staff and publishers, what do they understand by publishers? A media owner is a publisher. And so if you can put a publisher in jail, a media owner in jail, that's not what the Constitution says. And why should custodial sentence be even part of the conversation? I mean, why can't they say, okay, if you go contrary to certain laid down rules, your license or your authorization be taken away from you? Why should it amount to custodial sentences? And these are matters that are very, very worrying. We also feel that there are certain parts of the new regulation that are not very clear. It talks about programming guide. A programming guide, to all intents and purposes, amounts to bringing your programming guide for authorization, amounts to censorship, because now you want to find out what programs we are going to do. And it's not something that it's not something that we should encourage, if I should put it that way. It's not something that we need to go back to. We need to just look at ways. There are so many other ways that we could do this. There are so many ways we could engage and make sure that all broadcasters are responsible, going by the rule book and all that. But when we stick to criminalized media content, then it's a bit of a stretch for us, and that's why we're going to court.
So when exactly are we to have our first hearing in court?
Oh, we just filed a statement of claim. Last Friday we did that. So the NMC has 2 weeks to respond, and then the Supreme Court will fix the date. But as it is, we are also still engaging, as I explained to you the last time. We are members of the NMC, and so we're just not happy with this particular regulation, parts of it, not the whole regulation. And so we want to have those matters adjudicated on. And then we sit down and talk. So we're still engaging them, we're still talking to them, we're still showing clean hands that we have nothing against the NMC. We have nothing against regulations. We have nothing against sanitizing the system. All we are saying, let's do things that are not contrary to the Constitution of Ghana.
Light bill is too much. Me, myself, last 2 months I pay 40 Ghana cedis. By last month and this month I pay 100 Ghana cedis. That one is too much increase. And then the water, if it flow more, we pay high money. It's good. Now the Ghana is too much. The people suffer because of the money problem. And then me myself, I don't have money.
Many thanks for your time here on News Desk. Let's move on and do a lot more issues now. This time, let's turn our attention to law. And former Attorney General Martin A.B.K. Amidu says a suit challenging the Supreme Court's ruling that ordered Alfred Agbeshi Woyome to return 51.2 million cedis to the state has no legal standing. Mr. Amidu believes common sense should have warned the plaintiff that the Supreme Court has no jurisdiction to set aside the earlier ruling or even review same. And the former Attorney General is the third defendant in the suit that also involves the current Attorney General, Marietta Ruapia-Opong, who happens to be the first defendant, and Alfred Agbeshi Woyome, who is the second defendant. Now, Abdullahi Yusuf Fanash Mohammed, a resident of Hohoi Zongo in the Volta region, wants the Supreme Court's decision asking Mr. Woyome a businessman to return 51.2 million cedis to the state, declared null and void. Well, my colleague Lorna has been this particular statement and joins me in studio now with extracts of it. So, Lorna, tell us much more about what this statement says in the first place.
Okay. So this statement is by former Attorney General Martin Amidu, who is appealing to the Supreme Court to throw out a suit by one Abdullahi Yusuf Fanesh Mohammed, who is seeking to squash an earlier decision by the Apex Court, which ruled that businessman Alfred Agbesio Woyome should pay the 51 million cedis he owes the state. Now, we remember in the President's recent interaction with the press, he mentioned that a suit had been filed which prevented them from making those,
from taking the money.
From making those payments. So the suit filed by Abdullahi Yusuf Fanesh, a bit of it was stated in the affidavit by a former Attorney General Martin Amidu. And here it's saying that a declaration that the financial engineering claims by Alfred Agbeshiwoyome arising out of the tender bid by Vamed Engineering, Waterville, its wrongful holding abrogation as at August 2005, and is not international business transaction within the meaning of Article 181 of the Constitution, 1992 Constitution. Now, the Article 181 is saying that parliamentary approval is required in respect of international business transactions to which the state of Ghana is party. Now, the declaration is saying that the
So you're now speaking of the declaration by Martin Amidu?
No,
Abdul Fanesh.
Abdul Fanesh.
Okay.
Yes, he's saying a declaration on a true and proper interpretation of Article 2, verse 1, Article 130 and Article 181, 1992 Constitution. The Supreme Court has no jurisdiction to pronounce on the financial engineering claims between a citizen of Ghana and the government of Ghana, which does not fall within the ambit or purview of Article 181. He's basically saying that it's excess jurisdiction. The court that ruled does not have the jurisdiction to make such pronouncements, so he is seeking to reverse it. So here's Martin Amidu, former Attorney General. He has filed, he has this affidavit, and then in it he is saying that he is of the firm belief that the plaintiff or respondent's writ of summons and statement of case disclose no locus standi or cause of action vested in him against me or any of the defendants herein under the original jurisdiction of this court. He is saying, and I read, common sense should have warned the plaintiff or respondent that an ordinary bench of this court hearing his writ of summons and statement of case will have no jurisdiction to declare the ruling of the review bench in Amidu No. 3 versus Attorney General Waterville Holdings Limited and Woyome, null and void, or in any other manner attempt to review same under the smoke screen of exercising any original jurisdiction in this action.
That's
now,
interesting.
The plaintiff or respondent was warned or ought to have been warned by this court's decision in Okujeto Ablakwa No. 3 and another versus General and Ubechebi Lamte, in which this court decided that while it may depart from its own previous decision in terms of Article 129, Chapter 3 of the Constitution, until it had done so, it would be incorrect to argue that the Supreme Court is in error in following its own previous and unchallenged decision. And an applicant would face a difficulty in persuading this court that there was fundamental error in the judgment. Wow. So basically, Martin Amidu is saying what the guy has filed, it has no basis. The court should just throw it out.
Interesting.
The money needs to be retrieved from Agbesio.
Interesting. Many thanks for your time, Lorna. And
thank you, Pablo.
Really, that was my colleague Lorna reading extracts of that particular statement. And I need to let you know that if you go on myjournline.com, we have those two statements. The one is a 7-page document. The other is a 25-page document. It's all on myjournline.com. You can go there and read the full writs by former Attorney General Martin A.B.K. Amidu. You're still watching News Desk here on your Join This channel on Multi TV. Time now for some business after this break.